Hi, Steve Carlson here. The New York Times Opinion has written a really disgusting and arrogant article today commanding the entire country to follow its opinion on marriage. I am rebutting it on Twitter, and I'll summarize my rebuttal here. This panel of opinion writers pretends they have a watertight argument, but it falls apart on reflection. As follows. The New York Times says, quote, "The Supreme Court could not have been clearer when it ruled late last month that states may not refuse to marry same-sex couples. The right to marry is a fundamental right inherent in the liberty of the person," Justice Anthony Kennedy wrote for the court in Obergefell versus Hodges. Under the Due Process and Equal Protection Clauses of the 14th Amendment, couples of the same sex may not be deprived of that right and that liberty, unquote. Well, from this infinitely clear command, the editors derive all sorts of warnings and admonitions for judges and courts all around the land. I think their opinion is mud for the following reasons. First, I asked the editors this simple question. You are incorrect. What Kennedy wrote was states may not deprive individuals of their right and liberty to marry. Do you disagree? And of course they can't, because I have correctly stated Kennedy's proposition. I then observe that Kennedy's core premise is a credo that, quote, "the right to marry is a fundamental right inherent in the liberty of the person," unquote. First, although I must say the emperor has clothes, even if he does not, his premise is obviously wrong. This can be easily shown, but regardless of his idea's worth, his command simply cannot be found in the U.S. Constitution. Accordingly, since he is attempting to make policy, which is not the court's function in the first place, his command need not be followed at all, and it's therefore not illegal to totally disregard this entire spectacle at the U.S. Supreme Court. So why is he wrong? Well, polygamists are persons, right? And polygamists call multiple spouses marriage. Per Kennedy, then, this is a right fundamental in their liberty. It is fundamental in their liberty to treat their polygamous relations as marriage. It's part of being a person, and Kennedy can neither detract from this, nor can he add to it, nor can we. And the court need only await a case, and they are not bound by Kennedy to admit such practices must be accepted as lawful marriage all throughout America. So they are bound by Kennedy, according to him, to admit that these practices must be accepted as lawful marriage all throughout America. Now, a justice cannot augment what is already a fundamental liberty that he claims resides in the persons themselves. They have a fundamental right, he opines, to do whatever they want with their bodies and those of other consenting adults, and they are free to call that marriage. And it seems to follow from his opinion that whatever they call marriage, using that fundamental and inherent right, really a kind of natural law, we must all agree with them that yes, that is indubitably and inherently marriage. Well, since children are also persons, if a child explains to you that he is married to the little girl next door and they've arranged to have their parents raise them separately, that also is marriage. It's fundamental in their liberty. They were born with that liberty and may never be separated from it. All courts and legislatures, and indeed all of society, are simply required to go along. Justice Kennedy would hold us liable should we dare to disagree with these children. And I recognize that the term consent may be regulated, although I think that too is a slippery slope when the fundamental right consented to is inherent, or the right to consent, isn't that liberty? And it's inherent in their liberty as a person, and they are indubitably persons. Or polygamists, or individuals who claim love is the law based on their long-term sodomizing and fellatio and nakedness with each other, or cunnilingus. The whole gamut, as long as consent can be shown, all are marriage. And Kennedy says due process and the 14th Amendment require all governments to respect that, all states. But in whatever if whatever polygamists call marriage is a fundamental right inherent in the liberty of the person, which the New York Times editors insist is so clear, and if no state official may stop them, the question remains, is there anything the state official is required to do, or indeed even can do, to empower such an act as marriage, which is, says Kennedy, really just to express by some utterance that they are married? And the answer is clearly, could not be more clear, no. There's nothing at all required of the state, because no process or law of the state is necessary. Nothing else is required. You don't need a ritual, a ceremony, a wedding cake, flowers, none of that. If they say their relationship is marriage, then it is. Because, assuming for argument, Kennedy is right, it's inherent in their liberty. We would simply all be fools to not recognize it. If being married is simply a fundamental liberty per Kennedy's state religion and faith, then it needs no help from the state. It follows that no due process is required. No equal protection from any law is required, because no laws are required at all. It is simply a natural law. It's not in the Constitution, it's in nature. And what is illegal and invidious to this Obergefell court is the making of any law that grates up against this natural law, which places the power of marriage solely in the consent of individuals, not just two, to utter that their affairs are recognized and consented to by them as marriage. It can't be regulated, Kennedy tells us, and that command does not require any action at all from any government. If churches agree, fine. If they disagree, it cannot alter the fundamental, inherent, and the fundamental, inherent, and natural fact discerned by Kennedy that they are married. Perhaps if the individuals consent, the churches may counsel them and propose theories of sin and redemption. Some religions may attempt to impose laws, and the court would view that with consternation. But short of imposing such laws, which are absolutely prohibited, there is nothing required of government. And indeed, in Minnesota, marriage licenses were not the law until the 1970s. And there is no reason to suppose all the Minnesotans before that time were not married. Indeed, all Kennedy in reality argues in his opinion is that to deny this operation of the natural law of inherent rights, which by definition preceded the state, or to thwart it in any way is therefore simply to persecute these folks, who, it turns out, were married all along, from the moment they presented themselves to a registrar as such. No inquiries, no regulations are allowed. And so I think the New York Times editors are wrong in simply trying to threaten and bully people who are understandably befuddled by this flourish of commands and admonitions and completely unrestrained sexual relations in the new world of the Obergefell court. I'm Steve Carlson. I'm running for president as an independent candidate, and I want to restore common sense and rationality. I'm a radical centrist, and that is the kind of analysis that we need to get ourselves out of this quagmire at the United States Supreme Court.